A very good afternoon to all the people watching online. Welcome to another session of Lunch and Learn. And today we will be discussing and delving into the issue of how does criminal prosecutions work when it comes to maintenance matters. Good afternoon. My name is Eugene Opperman. I'm a family law practitioner practicing mostly in maintenance law, domestic violence, and children's rights issues, and I'll be hosting the presentation today. So what we will be discussing today, if we can just pop up the webinar overview, we will be looking at when is it a criminal offence if a person fails to pay maintenance in terms of Section 31 of the Maintenance Act. We will also be dealing with some case law regarding sentencing, have a short discussion thereof, and also discussing what defences could be raised by the respondent if he is not paying or not compliant with the maintenance court order. We will explain to you how does criminal prosecutions work and how the state needs to prove the elements of the offence in order to find the respondent guilty. We'll be discussing what constitutes a guilty mind of an accused when not paying maintenance, and walk through step by step how to lay a criminal charge and what to expect when you go to criminal court. We will be discussing in very short terms, briefly, Section 305 of the Children's Act, but that we will be dealing with in an upcoming webinar. So that might be quite interesting, as well as conversions, how a criminal trial will be converted back into a maintenance inquiry. And then lastly, we'll be discussing the different kinds of warrants of arrest that the court might issue in order to gain the presence of the respondent in court. But without further ado, let's just get the logistics done. Welcome to all the registrants, the people that have registered on our web portal, on our website, on www.lunchandlearn.org.za. If you have registered, you would have received a link bringing you to our webpage with some pre-reading material, as well as the link to the live webinar. But most importantly as well, like I always say, is the resource and templates tab, where you would find the copy of the handout, the course handout for this webinar, as well as the slides and all the documents that we will be referring to during this webinar. But without further ado, I want to start off with when it comes to maintenance and the payment of maintenance. I just want to give you a short recap there. So there are two remedies which you can use if the respondent is in default. Obviously, you would have the criminal one, the criminal aspect thereof, which we will be dealing with in this webinar. But just as a short recap, remember, there is always the civil remedies that is available to the complainant if the respondent is in arrears. Now, some people think that you can only choose the civil side or you can only choose the criminal side, and that is not true. You could use both remedies to your disposal to institute, for example, a garnishee, or to bring the application for enforcement in terms of attachment of debt or emolument attachment order or execution against property. And at the same time, you could also lay a charge for criminal charges for failing to pay maintenance. Just a short overview of the civil remedies that are available in terms of Chapter 5 of the Maintenance Act. You would have the warrant of execution against property, where the sheriff would go out and they would attach some of the movable goods of the respondent to be sold by public auction in order to recoup the money that is owed to you. So that is one option that is available. The attachment of emoluments, like we know in the practice, it's a garnishee order where the money gets deducted from the respondent's salary and gets paid over directly to you. The other remedy that are available is the attachment of debts. If there is any debts owed to the respondent and you know of such a debt, then the court could make an order that that money needs to be paid over to you and not to the respondent. That is also available. Sequestration is available, which although it is not advised because it is a quite expensive procedure. Obviously, what we will be dealing with today is the contempt of court, the criminal side of the non-compliance with the maintenance order. And then lastly, future maintenance, that is also available where a person's pension fund and benefits in terms of a provident fund and so forth could be attached. Those are all the civil remedies that we will be talking that we talked about and we have discussed in previous webinars. If you do not have the access to the previous webinars, please drop us an email on info@lanchandlearn.org.za and we would be happy to send you the links of the previous webinars. So let's get into the criminal side, the non-compliance. How does criminal prosecutions work? Now, criminal prosecutions are dealt with in Section 31 of the Maintenance Act, which reads the offences relating to maintenance orders. Now, if one looks at Section 31, 1 specifically, it says it comes in two parts. It says subject to the provisions of Section 2, which we will deal with now. Any person who fails to make any particular payment in terms of a maintenance order shall be guilty of an offence and could be jailed for a period of 3 years or a fine, or imprisonment without the option of the fine. So the legislator criminalized the non-payment of payment in terms of Section 31. Is that dealt with in maintenance court a lot? No. There are many reasons for that, but for obvious reasons, we will be discussing that throughout this webinar. The courts are not prone to institute criminal proceedings. It could be for various of reasons. It could be because the maintenance officer do not know how to do that. The prosecutors do not want to prosecute, or any number of reasons that there could be for not charging a person in terms of Section 31 of the Act for not complying. So now, like I said, Section 31 comes in two parts. It says right in the beginning, subject to the subsection 2. So what does subsection 2 say? But before we get to that, I just want to go back to where it says that the sentences that could be imposed are obviously jail sentence for a period not exceeding 3 years. So the respondent, if he's in arrears, could be fined either, or he could be sent to jail for a period of 3 years, or without an option of a fine. Those are available. Those are the remedies available. In terms of the Criminal Procedure Act, there are also different kinds of sentencing that are available. And it could be set in the alternative, but it would be in the discretion of the court to decide which would be an appropriate sentence. And we will be dealing with that in some of the case law coming up next. So obviously, what the court could do is they could issue a fine. If one looks at it holistically and practically, if the respondent gets a fine for not paying maintenance, where does that money go to? The fine money goes to the state, and it's not as of little benefit to the complainant, because they do not get the monetary value thereof. If the magistrate in sentencing gives a fine, the money goes to the state and it does not go to the complainant. Imprisonment in terms of Section 267 2B of the Criminal Procedure Act, yes, the courts may sentence a respondent to direct jail time. Now, that's also a contentious issue, because the reason would be that if a person is sent directly to jail, then he does not have the opportunity to go out and work and to bring in money. So there will not be maintenance, and that would not be beneficial. So there is a conundrum, and it's a lot of talk in some of the magistrates or officers dealing specifically, is direct imprisonment a suitable sentence for a maintenance defaulter? One of the other sentences that the courts usually impose is a suspended sentence, where they would say that they would give you jail time of 3 months or 6 months or 2 years, but that is suspended on the condition that the respondent pays the maintenance or pays the rear maintenance off in certain increments or before a certain period of time. So that is the most common one that the courts usually give as sentences. Obviously, if a person then falls into arrears, then you could approach the court for the suspended sentence to be changed to direct imprisonment if he fails during that period of suspension to pay maintenance. So that is basically like a sword over his head. Does it work in practice? Yes, it does. It does seem to have some deterrence. But most oftenly, in my practice, I've found that there are so many people, you know what, they just stay in default and they simply just don't care. And then the courts don't know that there have been suspended sentences because the prosecutors are not prone. They do not like prosecuting maintenance matters. The other option is also correctional supervision, where a person is sentenced to jail time on condition that they are could be left out or could be placed under correctional supervision at the discretion of the Department of Corrections. And that basically means that they are under house arrest, and the Department of Correctional Supervision would go out to the house. They would visit the house to see if he's there. He's only allowed to go to work, to the shops, not allowed to go and party over weekends and so forth. So they do the checks that as well. Problem with this type of sentence is that the Department of Corrections are grossly understaffed, and it's not properly enforced. Periodical imprisonment, that was quite a nice one, which I liked when I was a magistrate a number of years ago. I would used to send people to sentence them to periodic imprisonment. What that basically means is that, you know what, they drink and they party over weekends. So I would sentence them to jail time over weekends, where they would need to go to court or to jail at 5 o'clock on a Friday, and then be released on a Monday morning at 8 o'clock, just ready for work. And very often that seemed to have the correct effect, because that the word spreads in the community. I've had discussions with some of the big prisons. I've spoken to a couple of senior magistrates, asking them, why do they not enforce this? Why do they not give periodical imprisonment? And the reason for that is simply that the jails at this stage are so overburdened, so full, that they simply do not have the capacity to take in additional people. So these people that are sentenced for periodical imprisonment are just sent away home, which is basically a failing of the judicial system and the failing of the correctional service structure that we have. So if we unpack section 31 that I've just discussed, where it says subject to, and that's just coming back to the subject to portion thereof, it says subject to the provisions of section 2, if a defense is raised during the prosecution of the respondent for failure to pay maintenance in accordance with a maintenance order, a valid maintenance order, then if it was due to lack of means on the part of the person charged, he could be excused. That would be a valid reason, unless the failure was due to his unwillingness to work or to misconduct. So if we unpack section 31, specifically subsection 2, there are three elements that we need to look at. The one is the lack of means. So obviously there would be a defense that could be raised by the respondent or the accused at this stage then, due to lack of means. That would be the one portion thereof. The other would be that the failure was not due to his unwillingness to work. So if he just sits at home and he's not interested in working, he could not use this type of defense, because there should be a failure that was not due to his unwillingness to work. Also, the failure was not due to any misconduct. So if he slept at work, or he was drunk at work, or something like that, and he got fired as a result of his own conduct or of his own misconduct, then he could not rely on this portion as a defense that, you know what, simply I do not have the means to pay because I lost my job. But if it was on my own accord and it was my own fault that I was fired, then the court would not entertain that. So section 31(2) deals with that specific aspect. Just to come back, and it's also important, and it's not done by the maintenance officers or the maintenance court quite often, and that's the provisions of section 31(4) that says that if a person is convicted of an offence under section 31, then those details of that respondent needs to be given to the credit bureaus. So that would have a direct influence on his credit worthiness if he wants to apply for at a retail shop for a new TV and so forth. So that would be taken into account. Also, what is important specifically with regards to this section is that the maintenance default or the maintenance order needs to be listed on the credit bureau, because that would have a direct influence on the creditworthiness if he would to apply for something at a retail shop, for example, a TV, in order to establish that he is not overburdened or overdebted when it comes to the application of a debt. So very important. There is a lot of talk about this at this stage, the blacklisting of maintenance defaulters, and that is still a work in progress. I know that the South African Law Reform Commission has also dealt with this, and there are certain proposals on the table with regards to amendments specifically of this in the Act. So case law dealing with criminal proceedings, there are many cases that deals with this. I want to single out a couple of those, and the one is the State versus Visser case. It's a 2004 case where the trial court recommended that the amount of hours to be served for jail time be reduced for 500 Rand, each and every 500 Rand that he pays. So this was a sentence. Remember now, the magistrate giving out the sentence does have a choice of the fine or a suspended sentence and so forth. So in the Visser case, the magistrate said, I am sentencing you to a certain period of time, jail time, jail time, but for every 500 Rand that you pay off, that amount of jail time would be reduced. Now, in terms of me having been a magistrate previously, and looking at case law, this was quite a strange sentence for that. And the matter actually went on appeal, and the appellate court said that this is not a suitable or a practical or even an enforceable sentence. This next case, State versus November, and three similar cases. That was a Cape Town decision in 2006. The suspension of a sentence that the defaulter pays off maintenance of arrears. That has been dealt with in these cases. And in all of those cases, the court held that a proper account should be taken or should be considered of the defaulter's financial means. So there needs to be an investigation about, before they sentence the respondent or the accused, that there needs to be a detailed inquiry into his financial means, because it can, if they do not do that, it could mean inappropriate lenient terms in terms of payment of the arrears. So there needs to be some form of investigation. This is not done in most of the courts that I deal with, unfortunately. Another case, the State versus Seroke, 2004 case, where the judge held and said that imprisonment will almost certainly result in loss of employment by the defaulting parent or the person responsible for paying the maintenance. There's greater equity and fairness in ensuring that whatever money a person is obliged to pay, maintenance is paid towards maintenance rather than to be spent on legal representation or fines imposed by the courts. So even the courts are of the view that although there are the option of direct imprisonment, that these should be used very sparingly, because it might result almost definitely in loss of employment, and it would do no good if the matter is just then postponed each and every time, and money is spent on legal representation or fines imposed by the courts, rather than paying maintenance, because the money needs to go, ultimately the money needs to go to the children that needs the maintenance. So in practical terms, how does criminal prosecutions work? Obviously, there's about 5 steps that we need to follow. First of all, one should always remember that we work with 2 separate issues. That's why I started off right in the beginning to explain the civil remedies that are available, and we deal with criminal remedies that are available that we're dealing with now. Now, that is a complete separate portion. It's 2 completely different courts that might deal with this. Very often, as the courts are structured, the civil matters, the maintenance would be dealt with a civil court, and the criminal matters will be dealt with by a criminal magistrate, which might not be the same magistrate hearing the maintenance application form. So it might be a different court right at the other side of the court building, dealing with all the criminal matters that needs to deal with maintenance defaulters in terms of Section 31. So just in brief, how the process works, or the people that plays a role in criminal prosecutions. Obviously, you would have the complainant. The complainant needs to lay a complaint. The complaint needs to be taken to the maintenance officer. Strictly speaking, you could go to the police station to open a criminal case in terms of Section 31, although every police station would refer you back to the maintenance court, although legally and strictly speaking, you would be full within your rights to go directly to the police station to lay a charge in terms of Section 31, to be investigated and to be prosecuted, because it is a criminal offence in terms of the Act. Normally, what happens is and there are certain forms that needs to be completed. We'll get to the forms, the J470 later on, but the complaint needs to be laid by the complainant, and usually the form gets handed over to the maintenance officer. The maintenance officer would look at that, see if there's anything else needed. They would take the documentation. They would ask the maintenance investigator to investigate certain of the allegations, maybe get a credit report or a e-notice report or anything to that effect. So the maintenance investigator might also be involved in this whole process, and then this whole file gets taken and given to the public prosecutor. The public prosecutor is the person responsible for instituting legal proceedings on behalf of the state if a crime or an offence was committed. So in this case, there was a default in paying maintenance, which is a criminal offence in terms of Section 31 of the Act. So the public prosecutor needs to prosecute the accused or the respondent for non-payment of maintenance. So the public prosecutor would be the person responsible for taking this matter to criminal court. And then obviously the criminal magistrate court would also get involved with trying the matter, hearing the evidence, and then ultimately handing down a judgment in this case, or the specific case. So Section 31.1, if we look at further unpacking Section 31, what elements of the offence is there that the state needs to prove? Remember now, there is no burden of proof on the respondent. The state needs to prove beyond a reasonable doubt that a certain crime has been committed. So Section 31.1 distinguishes between two requirements that is necessary to be proved by the prosecution. The one is obviously that there was a valid court order. That is easy to prove because that would normally be on a copy thereof would be on the file, on the maintenance file. And then B, and this is probably the one that gets a little bit more problematic, that there is evidence that the respondent has failed to comply with that court order. So it's not up to you just to make that allegation, just to say, you know what, he did not pay for that. There needs to be some kind of proof, some kind of evidentiary supporting affidavits or banking statements and so forth to prove that the respondent was not complying with the court order. Because ultimately, by not paying the maintenance order results to a contempt of a court order. And therefore a criminal charge could be laid against that respondent. So just in recap, two things that needs to be proven: that there was a valid court order and that there is evidence that the respondent has failed to comply with that. And remember the burden of proof, that it is up to the state, the prosecutor, to prove that beyond a reasonable doubt. There is no onus of proof on the respondent to prove or to disprove anything. There are certain exceptions, and we'll deal with that as we progress with the webinar. So looking at the Section 33.1 requirements, if we look in terms of case law, what does the cases say? Because we do have the Act and we have got this Section 31 on the law books, but we need to look practically, what do courts say when it comes to the enforcement thereof. Now, one of the cases that I found was State versus Magagula. That's a 2001 case where, and this all deals with the requirements that needs to be proved, where the court held that a maintenance, or obviously there needs to be proven that there was a maintenance order directing payment of maintenance, failure on the part of the accused, obviously, and then very importantly, at the time when the accused failed to comply with that order, the state also needs to prove that he possessed the means to comply with a maintenance order. And if the state could not prove that he had the means to pay for that, and he raises the defense that he did not have money, that there was an unwillingness to work. So the state needs to prove that there's an unwilling to work or any form of misconduct on his side. The court, strangely enough, also brought in or mentioned, the judge mentioned that there needs to be a guilty mind, which includes the knowledge that he acted wrongfully and that his action amounted not to comply. So he was in default, and he knew willingly that he was in arrears, and he wanted to do that. So he knew that what he was doing was wrong. So that was what was decided in the State versus Magagula case. If we move on to this is an unreported case in 2022, handed down on the 15th of March last year, in the matter of SJD versus RKL. The court looked at what is the definition of contempt of court, and because ultimately failing to pay maintenance in terms of a maintenance order is contempt of court. It's in contempt of a valid court order, and it is seen as a deliberate intentional disobedience of an order granted by the court. And the court reiterated in this case, the SJD case, that the onus of proving the contempt lies with the applicant. Now, who's the applicant? The applicant usually, if one looks at in this matter, it was the complainant that went to the maintenance officer to say, but you know what, I have a problem, they did not pay maintenance. But ultimately, it's the state that needs to prove that. So you, as the complainant in this matter, the one that needs the maintenance money, the one that wants the court order to be enforced, you will be a state witness. But we'll get to that in a moment. The court said that, just reiterating, that the onus of proof lies with the applicant. The applicant has to show beyond a reasonable doubt that there was a maintenance order granted. We talked about that the respondent was aware of the court order and still failed to comply with that order. So this was reiterated in quite recent case law as well. Coming to the guilty mind portion, the courts alert to that, and they mentioned that there needs to be a unwillingness to work, but there would also need to be the knowledge that he acted unlawful. So he knew about the court order. He knew that he was supposed to pay, and he willingly not paid. He did not pay, and he knew that he had to pay. And that was where the guilty mind aspect comes in, and that was discussed in the State versus Mbuti case, where the learned judge said that a guilty mind can include the willful intent not to comply with a maintenance order. Someone just simply says, I'm not going to pay, and that is it, finish and clock. It could also mean a constructive intention to the same effect, that they do not want to pay, or a negligent failure to comply with a maintenance order. So once those elements have been proven by the state, then it's actually immaterial to discuss the guilty mind underlying his unwillingness, because the statute, in terms of Section 31, only requires the aspect of unwillingness to work, and then by implication that he knew of his unlawfulness by not paying the maintenance. So how does it work in practical terms? Let's get more practical. That is what we're all here to listen, how giving you the background so that you have the knowledge thereof, you know how it works, that there's no misunderstandings. But how do you lay a criminal charge when a respondent fails to pay maintenance, or he might be in arrears of maintenance? First of all, you start off by completing the Form Q. That is the J470 form. It is a simple form that you need to indicate how and in which manner the respondent is in arrears with his maintenance payment. With other words, how has he failed to comply with the maintenance order? And you must also indicate what is the outstanding amount that needs to be paid. We'll be discussing in a moment, we'll discuss how to fill in the J470 form. But that is in essence what is needed in order to start off with this whole process. That form needs to go to handed in or given to the maintenance officer. The maintenance officer would obviously use the maintenance investigator to investigate. And then this whole file will be given to the public prosecutor to prosecute on behalf of the state. And then the prosecutor has two different things that they could do. They could either summons a person on a J165, which is basically a criminal summons that a person needs to be in court, or if there is enough reason, they could issue a warrant of arrest for a person to be arrested and be brought to court. And obviously, once that person is at court, then the criminal trial could start. And then the proceedings would follow. But that would be dealt with in the criminal court and not the maintenance court. And I'm going to say that again. It's two different courts that we talk about here. The maintenance investigation, the maintenance inquiries all happens in the civil portion of the magistrate court. And then the criminal aspect, the criminal charges will be dealt with by the criminal courts in the magistrate office. So what is the role of the public prosecutor? The prosecutor acts in terms of Section 54 of the Criminal Procedure Act, and it is not for the maintenance officer to place the matter on the criminal roll. I'm going to repeat that again because people think that, and they get angry with the maintenance officer because they do not want to criminally charge the person. It is not up to the maintenance officer to place the matter on the criminal roll. The maintenance officer do not have the authority. In terms of the act, they do not have the authority to prosecute because they are employed as maintenance officers by the Department of Justice and not public prosecutors. So the public prosecutors act in terms of Section 54 of the Criminal Procedure Act, and they decide if they have the docket in front of them. Think of it as your docket of non-payment of maintenance that lands on the desk of the prosecutor is very similar to a murder case or a rape case or a burglary case. It needs to be investigated, and then the prosecutor decides how to deal with that. It is up to the prosecutor acting on behalf of the state, being dominus litis, acting on behalf of the state to criminally prosecute offenders. It's not up to the maintenance officer. Obviously, there's a responsibility on the prosecutor to make sure that there's enough information in the docket that they need to prosecute in order to get a successful conviction at the end of the day. So they would liaise with the maintenance officer in all likelihood to get more information in order to make their case as strong as possible in order to get a successful conviction. It is up to the prosecutor to draft the charge sheet, and that's basically what is needed in order to go to criminal court. And they could also ask for alternative or charge alternative offences. For example, if they charge a person or a respondent or an accused in terms of Section 31 of the Act, there could be alternative charges. If there are minor children involved, obviously they would in child maintenance. Then they could add Section 305 of the Children's Act that speaks to children's neglect. They could put that as the alternative, and a person could be charged for that as well. Now, alternative charges works basically if a person is not found guilty on the first charge of not paying maintenance, then the alternative charge kicks in, and then the magistrate could have a discretion of also convicting a person on the alternative charges. Very similar to the child Section 305, is also if one deals with spousal maintenance and the arrears of spousal maintenance, then the Section 30 of the Older Persons Act might also come into play, and that could be put in the alternative. Like I said, if you need the J470 form, that is the complaint of failure to comply with a maintenance order for purposes of Section 31. It's basically criminal charges. The form is available on the DOJ website. Those forms are also available at court. You could just ask for a copy, or you could just simply scan the barcode and it would take you there. But the documents are freely available that you could use. Completing of the form is quite straightforward, but it's important for you as the applicant and the complainant to show how the arrear amount is calculated. And our suggestion would be to fill out and to complete an affidavit, inclusive of all your banking statements and everything that is needed to prove to the court that he is in arrears, to make the work of the maintenance officer and ultimately the prosecutor that needs to drive this case in criminal court so much easier. So do an affidavit stating all the facts, everything that you have, give your banking statements that he has not paid in as proof as well, because the prosecutor would most definitely ask for that when it comes to trial. So what happens in criminal court? Obviously, once you go into criminal court, remember I said it's two different courts. It's not the maintenance court anymore. It's the criminal court. Obviously, once you get to the criminal court, your rights need to be explained. So the right of legal representation would be explained, because the accused is then asked, do you want legal representation? If you cannot afford one, legal aid might come to your assistance. But in terms of the Constitution, he's entitled in any criminal proceedings to have an attorney present to represent him in a criminal trial. Very importantly, remember, you as the applicant or the complainant in this matter will be subpoenaed to act as a witness on behalf of the state. So do not lie, because that would just be to your own detriment. You would act as a witness for the state in this matter. And the prosecutor will ask you the necessary questions, and there would also be an opportunity for the attorney of the accused to have you cross-examined should it be necessary. And then obviously there would be the presentation of evidence relating to the existence of the maintenance order and the outstanding amount and all the other relevant information that needs to be put in front of the court. So this is a schematic diagram of what you can expect, what happens in a criminal court. And it's important that you understand that, so that you know that there are no surprises. It will not be like you go to the maintenance officer's office, you stand in a queue and you wait for your turn. It is a formal procedure in terms of the Criminal Procedure Act. And I think it's vitally important that we go through this, and let me explain to you exactly how it works. So first of all, like I said, the respondent would be either he needs to come to court. So and that could happen in two different ways. Either the public prosecutor could issue a summons, a criminal summons, a J165, or they can arrest the person with a J50 warrant. Once that person is at court, if they are at court, then the prosecutor would read the charge out to the accused and the charge at that stage, and then the matter might get remanded. And if the person was arrested, the magistrate might pose bail to say, okay, right, you know what, you can go out, but you need to pay a certain amount of bail, or they might just be released on warning, or the matter might be postponed for further investigation and ultimately for trial. Once the matter comes to court on the next day, or the final court day for trial, there are two pleas that could be tendered by the accused. Number one, he could plead guilty. He could say, you know what, I am guilty. I have not been paying maintenance and so forth, and I admit all the elements of the crime. And then a judgment of guilty is entered into the record by the magistrate, and he would be found guilty of not paying maintenance. They would also then, the accused would have the opportunity to give forward to the court circumstances of mitigation, why I should get a lesser sentence, and then a sentence would be imposed. And obviously the respondent would have the right of an appeal or review if he feels that the sentence is too harsh. So that is on the pleading of guilty side. Most often the the parties would plead not guilty. They would say, we plead not guilty, and then the matter will be set down for trial. During the trial stage, you as the state witness will give testimony about the court order, the non-compliance thereof. The maintenance officer might be requested to testify, and all the witnesses that you might have would also be invited to testify. Remember that there will be an opportunity for the opposing side, for the accused attorney, to cross-examine you. So be careful what you say. Keep your answers as short as possible and answer truthfully each and every question. Obviously, once the state has presented their case, they close the state's case, and then the defense, the accused, will have, or the respondent, the father, would have the opportunity to put forward his side, his version thereof. And then very often they plead that they do not have the means, and so forth, and the reasons why they could not pay. Then after they've done that, you, on behalf of the, or not you, the public prosecutor, would have the opportunity to cross-examine the accused, to bring out nitty-gritty and faults and indiscrepancies of the defense case. And then after the closure of the defense case, the court would give out judgment. The court could then say, okay, right, you're guilty or you're not guilty. If he's found not guilty, obviously he walks. If he is guilty, then there would be a plea for mitigation and appropriate sentence. It could be a fine, it could be suspended sentence, it could be correctional supervision, and so forth. But in all of this, one thing that is important is that no matter if he is found guilty or not guilty, it does not bring in 1 cent towards that child that is in arrears for. And that is my biggest problem also with the criminal proceedings, that the money, if a fine is imposed and so forth, is that the money goes to the state and it does not go to the people that actually need that. Section 305 as an alternative, we've discussed that, but we will be discussing this in depth, how to proceed with Section 305 in further webinars. So I'm just going to for now, so that you are aware of this might be an alternative. Section 305 says a person who is legally liable to maintain a child is guilty of an offence if that person, while he was able to do so, fails to provide for that child with adequate food, clothing, lodging, and medical assistance. And that is in terms of the Children's Act, but we will be dealing with this quite extensively in a next webinar. Also important to note that if the alternative charges are brought in terms of Section 305, that upon conviction, that person could be placed on the child abuse register in terms of Section 110 of the Children's Act, or in the event of spousal maintenance, that person could be placed and he's found guilty of contravening Section 30 of the Older Persons Act, that he could be placed on the abuse of elderly register. Conversions thereof, very important to note, but we will also be dealing with this quite extensively. We are running out of time, but I'll soldier on through. Section 41 of the Act, very important to see or to note that it reads that if during the course of any proceedings in the maintenance court, that is now specifically with regards to the criminal court and the charges brought in terms of Section 31, or the enforcement of a suspended sentence. If they had a suspended sentence, and you have to come back to court in order to change that suspended sentence into direct jail time. If at that stage, and it appears on good cause shown that it is desirable to do so, the court may, on its own accord or on request of the prosecutor, convert the proceedings into such an inquiry. This is problematic, and this is happening all over South Africa. Criminal charges are brought, the defense is raised that, you know what, I do not have the lack of means, and then the matter is simply converted in terms of Section 41 to go back, referred back to the maintenance court in order to investigate that. Now, it does have certain drawbacks, but we will be discussing that in later webinars. Very important to note here is that it is only the court out of own accord or the prosecutor that may ask that during the proceedings, if there was good cause shown, and if it is necessary to do so, because the applicant or the accused does not have money, and so forth, and you know what, he lost his job, but it was not as his own fault, and so forth. And those circumstances, the criminal charge, the criminal case would be changed into a inquiry in terms of Section 41, and the matter would be referred back to the maintenance court for further adjudication. But we will be dealing with this quite a lot, because we see that this system is misused, specifically by attorneys or even maintenance officers, which request that, you know, we'll change it into a inquiry instead of running a criminal trial. It's very clear from Section 41, it is only the court and the prosecutor that may request that the conversion might take place, and not the attorney or the maintenance officer. I've mentioned that usually what happens is that they transfer it back to the maintenance court. There was a recent case, September versus September. It's an unreported case which was handed down in 2012 by Justices Binns, Ward, and Yekiso, where they said, you know what, no, it could be the same court with the same people sitting there, because the prosecutor in terms of Section 4 of the Maintenance Act is also deemed to be a maintenance officer. So they cannot say, you know what, we need to transfer the matter back. In the September versus September case, that actually said that the same court that was constituted in terms of the criminal court could also be used to attend to this inquiry, referred to in Section 41. But we will be dealing with this quite extensively and discussing the September versus September case in an upcoming webinar. The two warrants. Remember one thing, the warrant, yes. I know that some of the complainants feel that, oh, you know what, arrest the little bugger because he did not pay maintenance. And that is a type of a sentence or type of a punishment. Remember that the issuing of a warrant, what is the purpose of a warrant of arrest? The warrant of arrest, the sole purpose of a warrant of arrest is to bring someone to court in order to make sure that they stand trial. There's two types of different warrants that we use in maintenance. The one is the J165. That is usually handed down, we call it the bench warrant, that the magistrate, if a person is supposed to appear in court and he does not appear, that amounts to a criminal offence, because is on contempt of court, because he was warned or he was given a summons and so forth, and he did not appear, and then they issue a warrant of arrest, a J165 form. That is usually what happens, and then the police need to go out and arrest that person and bring them to court. But the sole purpose of the arrest warrant is to bring the person to court so that he could stand trial. In exceptional circumstances, the courts may issue a J50 warrant. That is the big one. That is the warrant that is valid throughout South Africa, and it could be circulated amongst all the police stations, and any police station could give effect to that J50 warrant. And that is usually done on request of either the maintenance officer or the maintenance investigator, in order to secure the presence before the person in court. And that is dealt with in Section 43 of the Criminal Procedure Act. It's not been dealt with in the Maintenance Act per se. This is just an example of what the warrant looks like. It's a very straightforward form. Usually they approach the magistrate in chambers and to ask them, could they, and the reasons. Usually the magistrate would ask for some form of proof that there was actually a crime that was committed. It might be in the forms of affidavits. That's why it's vitally important when you complete your J470 that you present to them enough evidence that a crime was indeed committed in order to convict the accused successfully. That is basically our presentation for today. Dealing with criminal prosecutions. It took me back years when I was a prosecutor and then subsequently a magistrate. So yeah, this was, is it done quite a lot in maintenance courts? No. And it's quite sad. What I would also just reiterate before we knock off is that, and that is a question that was asked by quite a number of people. What happens if the prosecutor simply refuses to prosecute? Is there any way that one could salvage that and could deal with that? And the answer is yes. It is up to the state, the prosecutor, to make sure that they have enough information in order to secure a conviction. But if they feel that they do not have that, then they can issue something that they call a nolle prosequi certificate. That's a certificate of that they're not prepared to bring the matter before criminal court. But there is a provision in the Criminal Procedure Act that you, as the complainant, if you're not happy with the prosecutor, either you can complain, but that would not bring you any much further, because the prosecutor is dominus litis, so they decide what's going on the court roll and what not. So if they don't feel that there's a strong enough case, they would simply just not put it on the roll. But there is a provision in the Criminal Procedure Act that you, as the layperson, can employ an attorney or an advocate to act as a private prosecutor, which would basically mean that you pay for an attorney or for an advocate, and they bring this criminal charges on your behalf. They use the same court, they use the same system. The only thing is that it is not the public prosecutor that then acts on your behalf, but the attorney or the advocate that acts on your behalf and sets forth your matter before the criminal court. So that is just something to bear in mind. Yes, this has been quite fun. Thank you for joining us today on this rather chilly day. If you want to reach out to us, please do send us an email on info@lanchandlearn.org.za. We love hearing from you. We love your comments, your suggestions, and just your general feedback on these type of webinars. It's quite important that we get those type of feedback to know, are we on the right track? What else do you need us to discuss? And yeah, give us the suggestions. If you have any queries as well, please send it through. Myself or one of my clerks will probably attend to those. And then we'll be seeing you next week, same time, same place, for some more Lunch and Learn seminars and webinars. Thank you so much for joining us. And please do go visit our website to register for future webinars as well. And we will be seeing you next week. Have a very good afternoon.